Hi, my name's Georgia and today I'm going to be talking to you a little bit about misleading and deceptive conduct. So what we're going to cover today is a bit of an overview of the laws about misleading and deceptive conduct. We're actually going to apply these to some of the phrases drafted for a prospective client from your PR agency. Hopefully, aside from 10 to 15 minutes less of your time, you will also walk away with a better understanding of the laws that apply around misleading and deceptive conduct, and specifically how they actually apply to your agency. Hopefully you can also walk away with a couple of key principles to remember that will help protect you and your organisation from a claim regarding misleading and deceptive conduct. So, the law. We're going to focus on misleading and deceptive conduct as defined by Section 18 of the Australian Consumer Law. Now, Section 18 of the Australian Consumer Law is found in Schedule 2 of the Competition and Consumer Act, which is available online. Now, the legislation provides the key principles of law, but the case law, isn't redundant. It provides essential boundaries and definitions. It allows us to see how the legislation is applied, and the principles in the case law are really needed to completely understand the legislation. Okay, so starting with the legislation, Section 18 of the Australian Consumer Law stipulates that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive. Seems like a pretty straightforward statement, but there's actually quite a lot there, and what we're going to do today is we're going to unpack some of that. And key to doing that is looking at the important elements of Section 18. So we've got a person, we've got trade or commerce, conduct, and the term misleading and deceptive, and each of those are things that we're going to step through with you in the next few slides. Now, person, the first element. This is probably the most straightforward element, but it's just really important to call out that the law doesn't just see a person as an individual. It also applies to businesses, and it specifically extends to partnerships. So that's the first element, and like I said, it's probably the most straightforward, but really, really critical to understand that just because you're a business or part of a partnership or a company, it doesn't actually mean that the law won't see you as a person engaging in misleading and deceptive conduct. Now, in trade or commerce, this one is a little bit, there's a little bit more to it, and what we're going to do is we're going to look at a case that provides some out of scope, as well as the legislation which provides, some in-scope activity. So fortunately, the Australian Consumer Law actually does define trade or commerce, and it basically says within Australia or between Australia and places outside of Australia, which includes business or professional activity, which is really key here, whether or not it's carried on for profit. So as I mentioned, we're going to actually look at a case which just helps define more so what isn't included in trade or commerce. So, concrete construction versus Nelson. So basically, a worker was injured following incorrect information given to him by an employee of concrete construction. So along the lines of, he asked whether a grate was secured. The worker said yes. He injured himself based on that information, which happened to be incorrect, and he then sought damages, arguing that the conduct was misleading and deceptive. But the judge held that this conduct was actually not in a commercial context. So it was about the dealings between the employees, nothing external facing. It wasn't actually in the course of trade or commerce. Now, this is really important because it gives us that principle about what isn't considered in trade or commerce, and if it's not considered to be for the purposes of commercial trade or dealing, the Australian consumer law doesn't extend. Okay, so let's look at the next element, which is conduct. Now, conduct and misleading and deceptive conduct, I guess, could be grouped together, but just specifically on this, I wanted to call out that conduct is not only, things said and done, but things implied as well, and things can be implied by silence, which is a case that we're going to look at. Hopefully I get the principle of the case right, but I'm not too sure that I'll get the pronunciation of the case right, which is Demagogue versus Romensky. So forgive me if I have pronounced that one wrong. But again, this case just provides us with an example of how silence can amount to misleading and deceptive conduct. Right, so onto the case of Demagogue and v. Romensky. So in this case, there was a property for sale which required a special road licence to be accessed. Now, in selling this, the vendors actually failed to mention it. They didn't expressly convey that there was nothing unusual about access to the property, but they didn't mention it at all, and they stayed silent on the issue. So obviously, once the purchasers found out, they looked to rescind the contract, and the judge did hold that failing to mention that the permit or the license was required actually created the impression that there was really nothing unusual surrounding access. So their failure to disclose the information, which suggested otherwise, was actually misleading and deceptive. So again, this is just about silence being able to amount to misleading and deceptive conduct. So in the context of advertising, a failure to disclose something, just because it's not, you haven't expressly stated otherwise, silence can still amount to misleading and deceptive conduct where you have a duty to disclose. Now, misleading and deceptive. This is the meatier part. Not defined specifically by the Australian consumer law, so case law is really critical here. Now, the court has what I would call an objective approach to identifying misleading or deceptive conduct. We're going to talk primarily about the first two elements here in this presentation as it applies to the case that we're looking at. We're not so much going to touch on the third, but they look at who was the target audience of the conduct, and would an ordinary person from within that class, so within that target audience, be likely to be misled or deceived by the conduct. They'll also look at whether it was actually the defendant's conduct that created the misleading impression or whether it was something else, but we're not going to look too much in detail at that today. Okay, Google versus the ACCC. Now, in this case, the ACCC alleged that publication of sponsored advertisements which were misleading and deceptive amounted to misleading and deceptive conduct, but the judge actually identified that the target audience of the advertisements were likely to have access to and basic, proficiency and understanding of computers, as well as the internet and search engines. So what the judge actually found was that ordinary members of that class would understand that sponsored links that are published by Google are just links that they're passing on, and they're paid to pass on. So they're not actually statements that Google is endorsing. Therefore, from the perspective of Google, they couldn't be found to be misleading and deceptive. This is a really important case because it tells us that the overall impression of the conduct that's given or that's left on the ordinary person within that identified target audience is really, really critical. Now, one thing that's probably coming to mind is, well, who is the ordinary person? And that's something that we're going to look at in a little bit more detail shortly. So the ordinary person includes the astute and the gullible, the intelligent and the not so intelligent, the well-educated as well as the poorly educated, men and women of various ages pursuing a variety of vocations. So that was in Puxu versus Parkdale Custom Built Furniture. Another case that provides us with, I guess, a boundary that sort of rounds that off is it doesn't include the quite unusually stupid. So what we can establish from these two cases is that an ordinary person is pretty much anybody except for the unusually stupid. Now, disclaimers. Disclaimers are common. The question is, can they actually protect you from a claim around misleading and deceptive conduct? And the answer is no, not by default and not on their own. So if they create a misleading expression or they contradict the overall messaging of an advertisement, it's likely to be found misleading. And that's guidance from the ACCC. So there is a case that shows us, however, that people are still expected to take reasonable care of their own interests. So Butcher versus Lachlan Elder Realty, which we'll talk about in a little minute. Now, in this case, prospective purchasers were provided with a property containing a survey diagram which actually happened to be inaccurate. Now, the brochure also included just a disclaimer that pretty expressly conveyed that, the real estate agent believed the information to be true, essentially, but that persons should rely on their own inquiries. Again, people are required to take reasonable care of their own interests, but we need to go back to the court's objective approach here. So the judge identified that the class included reasonably wealthy purchasers reasonably wealthy individuals looking to purchase a property with a price range of over $1 million, holding that it was reasonable to expect that an ordinary person from within this class would actually consider the disclaimer. Now, this is really important because it's quite common in advertising, to allude to the fact that something may happen if you consume a product. Essentially, predictions can actually be found to be misleading and deceptive. So, if a representation is made and the person doesn't have reasonable grounds for making it, that claim can be found to be made misleading and could be found to be misleading and deceptive. An important exclusion, and it's just really important to distinguish what is actually puff. So what's an exaggerated claim, something that no ordinary person would really take seriously or as a representation of fact and would really just identify as sales puff. So these are generally statements that are not really intended to be relied on and are actually difficult to be proved true or false. Now, under Australian consumer law, we can have injunctions granted. In some cases, the claimant can recover damages and compensatory or preventative or mitigating orders, such as disqualification orders, can be issued as well. Now, let's look at the case study. It's a couple of things really quickly that probably seem obvious based on what I've discussed, but the PR agency is going to be considered by the law to be a person capable of engaging in conduct. The clients of the PR agency also, when they publish that information on their labels and they market it out to prospective consumers, that's going to be considered a person capable of engaging in conduct as well as in trade or commerce. But really key to determining whether the conduct is likely to deceive is identifying the class and its ordinary member. So we're looking today at some phrases that are potentially going to be included on the marketing of juice. So really it's reasonable to expect that any member of the public looking to purchase juice and an ordinary person from within that class is really as per that case we looked at before. So it's anyone except the unusually stupid is a good way to look at it. Now, first phrase, feeling like a whole new person is just a glass away. Now, I would look at this and ask, is it a prediction of the future or is it puff? Now, could it be proved either way that it's true or not true? And would an ordinary member of the public looking to buy juice actually rely on this? I would say that it is arguably just sales puff, and it's important to distinguish it as such. Give yourself a healthy start to the day. My question when looking at this is, but what about the sugar? And this is where the principle of silence comes in for me. Now, is it reasonable for a consumer to assume that a juice provides a healthy start to the day is the first question, and I think yes, it is. So therefore, it's probably not going to class as puff that's exempt from a claim of misleading and deceptive conduct. The important part here is what's the claim based on? So can it actually be substantiated? And the other piece is, does it create a perception that all of the ingredients are healthy? Remembering that silence can create a misleading impression. So the fact that it's partly true, this juice is primarily made of juice, but it has an added 1 teaspoon of sugar per serving. And if we're going to claim that to be healthy, the recommendation is to just make sure that claim of healthy is substantiated. Now, the daily juice is organic. This is something that is concerning to me. So again, if we look at the overall impression that's left on the general consumer, most people don't really know much about what's organic, and they're going to rely on what we tell them to be accurate. So this juice is derived from fruits and vegetables, most of which are actually not organic if we have a look at it. So in that sense, overall, the representation is only partly true, which doesn't really, in fact, it doesn't at all exempt it from a claim of misleading and deceptive conduct. So in terms of including a disclaimer, remembering that people are asked to required to protect their best interests, we have to ask whether it's reasonable to expect just a general member of the public looking to purchase juice, who's our target consumer, to actually review a disclaimer in order to protect their interests. And the other question is, would a disclaimer actually contradict the overall tone of the label? So we're saying the juice is organic, but then we're putting a disclaimer saying, but not really. It's really only 2 out of 7 inputs that are organic. So this is one that I would tread with caution, review those principles and review those cases, and really think about whether it's worth including this claim that's quite difficult to substantiate, at least in an overall sense, as accurate. Okay, I'm very sorry, I've ran over time by a few minutes, so I'm going to quickly run through this, but in conclusion, always consider the overall impression given by the claims and phrases that you put on a label. Importantly, distinguish between what is puff and what's actually a representation. Make sure that disclaimers are clearly worded and visible, but they really they can't contradict the overall tone of the labelling or the advertising. And also, if you're using a disclaimer, consider whether it's actually reasonable to expect a person to read the disclaimer. Number one, I guess the most important thing, make sure that all claims that you do make that aren't puff can be substantiated, and remember that silence can constitute conduct, and if it gives a misleading impression, that conduct will actually be found to be misleading and deceptive. Now, my final advice, just with regards to the case study, is avoid claims that the juice is organic. In an overall sense, it isn't true, and it could be found to contravene Section 18 of the Australian Consumer Law. Thank you.